Welcome to the Cheeley Law Review. My name is Ben Burnett. My guest in his own office today is Bob Cheeley. Bob, how are you, sir?
Better than I deserve.
I've heard that before a time or two. Bob, today we're going to talk about mediation.
So mediation is a way of trying to resolve lawsuits short of going to trial. There's not enough judges and not enough time slots available to try even probably 10% of all the cases that get filed. Most cases wind up getting settled, but where there's significant damages involved, injury, whether it's a personal injury, wrongful death case, catastrophic injuries, or whether it's a high stakes business litigation where there's a lot of damages at stake, those are the cases that typically go to mediation. Now, judges, not only here in Georgia, but pretty much everywhere, require litigants, plaintiffs and defendants, to mediate the case to see if there's a way to get cases resolved without having to come and tie up court resources and jurors' time.
If a plaintiff enters into mediation, is that some sort of admissibility that there is an issue with their case, or is that simply just a fact of the matter decision that you and your team help them come to?
It's not an admission of weakness or vulnerability. First of all, the trial courts uniformly require the litigants to go mediate, give it a shot at trying to resolve the case. So everybody knows that the judge is the one that's going to expect the parties to try to go mediate and then report back to the court if they've been successful or not. But secondly, it's not binding, but it is a good opportunity to test the resolve of the defendant. If I only represent the injured parties, and I'm always represent the plaintiff. But it's always good barometer to determine how serious the defense is, my opposing party, is at wanting to get the case resolved, because you get an opportunity to see the opposing party in more of a relaxed and non-intimidating setting. You're in a big conference room. Typically, you start off, both sides give basically a summary of their position in the case, and then they leave the room and go to separate rooms, and then the mediator basically he or she shuttles back and forth between the two groups. The plaintiff typically, will make a demand if they haven't already made a demand prior to the mediation, but typically we do make a demand early on in the case so that defendants know what the expectation level is. And then a lot of times they'll sit until mediation rolls around, and that'll be the first time that they make a response to that demand. Judges typically require somebody with authority to settle the case to be present. A lot of times that's a insurance claims manager or a representative of the company that's caused the harm.
Turn this on its head. If a defendant knows that there is some sort of wrongdoing on their side of the house, do they often approach you first about mediation, or is that when you know you've got them?
Sometimes a defense lawyer in a civil case that's defending a case that I've filed on behalf of a plaintiff, they'll recommend or raise the idea of, maybe sometimes early on in the case before we get into a lot of depositions, they'll raise the idea of, why don't we try to mediate this before we spend a bunch of time and money? And that's a good sign when that happens. And I just settled a case for just shy of $8 million about 2 months ago, where the lawyer on the other side suggested mediation. And we went to mediation, and we spent 3/4 of a day there, and they couldn't. They had insurance coverage. They couldn't get to where we wanted them to be after going back and forth. But about 3 weeks later, they did come back with more authority and financial authority, and we got the case resolved.
Knowing that the judges require a 100% participation in mediation, do you guys see that as a robust opportunity for your clients to reach what you would perceive as justice faster? And do you take it more seriously, or is that something that you just kind of go through the motions on? And what percentage of your clients do you recommend that for?
I definitely agree that It's a positive. I think the word you use is that a robust opportunity. Yeah, I don't ever want to be accused of being so recalcitrant that I won't discuss resolution of a civil case with my opposing party. Been doing this for 41 years, and I know that it's in the best interest of the client to fully explore that. A lot of times I have a client, though, that wants their day in court. I tell them, well, you got to go do the mediation because the judge is requiring it. We'll go do the mediation, but a lot of times we're very far apart, with the demand, and they're what the opposing party is willing to pay. And so but we do try to give it our best effort to get it resolved. And sometimes you have to go through a mediation and let some time go by, do depositions, get closer to a date of trial, and then
it creates urgency.
It creates a sense of urgency. And the defense typically will see that I've kind of surrounded them, as I call it, closing the circle, and they've decided that they don't really have any good defenses left. And so they'll say, why don't we go back in front of our mediator and try to give it another run at trying to get it resolved.
Is it a big world when you get into the mediation space in the state of Georgia or in the Atlanta metro area? Is it a big world of people who live in the mediation space, or do you guys all know everybody?
We know who the good mediators are, the people who get good results. We like to try to use a new one every now and then. There are mediation firms that you have retired attorneys and retired judges that get paid through those firms to do mediations. They generally have a pretty good cross-section of people, different experiences and different backgrounds to choose from. Sometimes, I'll have a case in one part of the state, and I might choose, like down in South Georgia near Valdosta, and we selected a mediator from Savannah.
Not too close.
Not too close, but both sides agreed. When I floated the idea to the opposing party, I was kind of surprised that they bit and agreed to use that mediator from Savannah and did a really good job. And one thing, too, that also helps is if you're in front of a mediator who maybe is a retired judge, maybe somebody that I've tried a case in front of in years gone by, it helps that mediator can tell the insurance adjuster or claims manager, hey, I've seen Bob Cheeley try cases, and he's going to be ready. Take it seriously and try to get this case resolved today. And I'll tell you, because you're either going to pay now or you're going to pay a lot more later. I appreciate that kind of opportunity to be in front of a mediator who has seen me in action.
You like your relationships?
I love my relationships. I really do.
This has been another episode of the Cheeley Law Review. Have a great day, everybody.